Here's the next priority question.
Thank you, Lance Corley. I want to ask the Minister about the letter of the 21st of October 2014 to the Trade Commissioner, which he co-signed together with a number of other trade ministers across Europe. The essence of the letter is to argue for the maintenance of ISDS, investor-state dispute settlement mechanism, giving privileged access to corporations to justice against states that attempt to regulate in the EU-US Free Trade Agreement, so-called TTIP. Can I ask the Minister if the government gave him a mandate to sign that letter, if that is the official government position to argue for the inclusion of ISDS, and if there has been a response yet from the Trade Commissioner?
Thank you, Minister.
The purpose of the negotiations of a transatlantic trade and investment partnership is to reduce barriers to trade and investment in order to generate jobs and growth. According to assessments made by the EU Commission and other European bodies, a comprehensive TTIP could boost EU GDP by over 0.5% per annum, converting into 400,000 additional jobs across the EU. The gains for Ireland could be double this in proportionate terms because of the significant flows of trade between Ireland and the US. Ireland was one of the 14 EU member states that wrote to the new Commissioner for Trade, Cecilia Malmström, expressing the view that the public consultation on investor protection in the TTIP held earlier this year was an important step in seeking to strike the right balance, and that stakeholders' contributions should be carefully considered before reaching firm decisions on the way forward. While no reply has issued to the letter, I am aware that the results of the consultation will be made available soon. The aim of the investment protection chapter of the EU's free trade agreements is to provide EU investors abroad with a level of protection similar to that which would obtain within the EU. In respect of inward investment, Ireland guarantees investors into Ireland that they will not be treated in a discriminatory manner. That protection is provided by way of our Constitution. However, all other EU member states have bilateral investment treaties with third parties that include investor-state dispute settlement arrangements, the so-called ISDS. 9 member states have such treaties with the US. TTIP would replace these with a single arrangement. Ultimately, an EU mechanism would provide a uniform system of guaranteed fair and equitable treatment for investors across all EU member states. International experience with ISDS points to a wide disparity of bilateral investment agreements, with some cases taken by investors under some of these have brought criticism on the mechanism. TTIP and other agreements provide an opportunity for the EU to make improvements that address the weaknesses identified in those other cases. The mandate for negotiation has made it clear that the objectives of any investor protection provisions would be without prejudice to the right of the EU and the Member States to adopt and enforce measures necessary to pursue legitimate policy objectives such as social, environmental, security, stability of the financial system, public health and safety in a non-discriminatory manner. Okay.
Thank you. I would be highly sceptical of the promised growth figures from the Commission. The similar figures promised in terms of NAFTA never materialised. 1 million jobs disappeared. Professor Clive George, who has previously done impact assessments for the European Commission, has noted their model is highly speculative and said that the actual growth rate likely increase is 0.01% per year over a 10-year period. Why do we need these for certainty of investment? Does the Minister think there's a fundamental flaw in the US justice system? Do they think there's a fundamental flaw in the European justice system? Why is the regular access to justice that any ordinary person can get, why isn't it good enough for the corporations? Why do the corporations and does the Minister want them to have the right to sue in private tribunals where they get to choose the arbitrator, they pay them an average of $3,000 per day and get to use causes like indirect expropriation to challenge at the moment fracking in Canada, where a corporation, Lone Pine, is suing for almost €200 million for a moratorium on fracking.
Thank you, Deputy.
Challenges against moratorium on nuclear power in Germany, challenges by the cigarette industry.
Good morning, Minister.
First of all, the EU has made provision that such hearings will not be in private, and the individuals involved will not choose the arbitrators. It will be the choice of the arbitrators will be by the two sides, the European Union and the US in the case of the US. Why are such protections necessary? I think it's if you are investing in many countries, and the EU has set up trade agreements is seeking to set up investment agreements with China, China, with Korea, with Singapore, with many countries. And in a lot of those cases, there isn't the body of law developed that one would need. So there's clearly a case for investor protection. In the case of the US, they obviously want to have a uniformity across the EU. But the EU, in its negotiating mandate, has sought to ensure that European interests are protected. Firstly, by insisting that public policy, freedom of public policy will be guaranteed, so you can introduce regulation in those areas. Secondly, like the Canada Agreement is a good model. The case where a challenge can be brought for fair, under these systems is where there has been, and they list them, a denial of justice in criminal, civil or administrative proceedings, a fundamental breach of due process, manifest arbitrariness, targeted discrimination or manifestly wrongful grounds, or abusive treatment of investors. Now, clearly those are protections that are very reasonable to have put into an agreement. And I think it's important to bear in mind that we are negotiating with the sovereign government in the US, and they equally are determined to ensure their freedom to regulate in areas. So this is an area where there's a mutual interest in having fair protection in such trade agreements.
Deputy Paul Murphy.
In my work in the European Parliament, I heard this argument again and again for ISDS in the case of trade agreements with countries with undeveloped legal systems. That was the argument put forward. But here you have the US, country with the most developed legal system in the world, and the EU similarly, and they still argue for corporations to have special rights, rights that are not afforded to ordinary people in either bloc. And the right is clearly it's a right of corporations to sue states that interfere with their right to make a profit. Does the Minister agree with the right of corporations to sue for what's known as indirect expropriation? Does he consider that our attempt to have plain packaging legislation, for example, in terms of cigarettes, could be challenged, as is currently happening at the moment in these tribunals under this kind of agreement, with Philip Morris suing Uruguay, with Philip Morris suing Australia? What's happening here is the right to profit is being put privileged above the right of states to regulate in the interest of public health, in the interest of the environment, in the interest of workers' rights. And it also represents a fundamental attack on our right democratically to discuss and to decide on these policies, as opposed to corporations setting the rules in private tribunals.
Thank you, Minister.
Well, the Deputy may have listened to debates in the European Parliament, but it doesn't sound like he learnt anything from them, because the mandate specifically excludes all of those social protection areas. Countries will have the right to pursue public policy objectives in all of those areas, and the model is set out in Canada. The Canadian Agreement has an investor protection mechanism in it, and it protects against the environmental protection is perfectly within the right of government to protect. So I think that's the first point I'd make. Clearly, investor protection is an important part of any trade agreement. If you're investing, you want to ensure, and I listed the things, that you are not arbitrarily discriminated against. So it is quite reasonable to put into EU agreements these sort of protections. They're in the Canadian Agreement. They will be in all future agreements. We have given, under the Lisbon Treaty, the European Union the ability to negotiate these sort of protections. They give our investors certainty in the countries in which we invest, and the same is true of the parties with whom we are negotiating. Countries, whether they be Chinese investors or Indian investors who don't have familiarity with our legal system, they will want to see that basic ingredients are protected, and that's the purpose of these mechanisms.
Thank you, Minister. We have to